Hello, everyone. My name is Tom Aiello, and I'm going to be discussing my book, Jim Crow's Last Stand. I'm going to vamp just for a couple of minutes here to let people find us, and then we'll get started. I should say that while I'm vamping, that this series has been great. I've learned a lot. My friend Liz talked about hurricane naming. That was very exciting. I learned a lot about that. I learned about Jane Austen fandom, which was really cool and weird at the same time. The idea that studying Jane Austen fandom is both a literary project, but also this kind of cultural studies, cultural history project. It was really interesting. I learned about leprosy in Louisiana, which, what? Right? And so I've learned a lot of interesting things from this series, and hopefully we can learn a little bit today as well. So now that we have a few people on board, let me introduce myself. My name is Tom Aiello. I teach at Valdosta State University in Valdosta, Georgia. And I'm here to talk today about Jim Crow's Last Stand, Non-Unanimous Criminal Jury Verdicts in Louisiana. This is the updated edition that came out last year. It was originally published in 2015. And it is a story that describes one of the most insidious programs in Louisiana history. A program wherein, for much of Louisiana's history, someone could be convicted of a felony with only 9 of the 12 jurors thinking that he or she was guilty. Later on, that became 10 of 12 jurors, but for the longest time, from the 1880s all the way until last year, that was the norm in Louisiana. And it still very much has relevance, especially in light of kind of the things that we are seeing in the news today, with this kind of what I'm calling an urban spring in response to the police murder of George Floyd, when we have started to kind of reconceive what criminal justice means. We in Louisiana have a kind of important special attachment to criminal justice problems that other places never had to worry about. We've had to play catch up specifically because of the system that has been in place with the same racial motivations that we are discussing with policing today. So, to discuss this and to get into it a little bit, I am going to read a little from the book in the style of our remote reading series here with LSU Press. And I'm going to read to you not really a piece of academic analysis. Instead, I'm going to read you a story from the preface to the updated edition. This is a true story. This is a story that happened to my wife and I, as I went and testified in one of the appellate cases for someone who had been convicted by a non-unanimous jury, who had been convicted when two of the jurors openly said that the person was not guilty. And my presence there was kind of as an academic to explain the racist roots of that law. But I'll read a little bit of that to you, and then I'll say a few things about how I think this phenomenon relates to what's going on in our present society. And then I'll take your questions, and we can hopefully learn some more along the way. So, the Sabine Parish Courthouse has no metal detector. It's the first thing that you notice when walking into the quaint but still imposing edifice in tiny Manny, Louisiana. Itself quaint and imposing in its own way. I traveled there in July 2018 to testify in an appeal of the second-degree murder conviction of Melvin Maxey, a conviction attendant with a variety of procedural inconsistencies, but also attendant with a non-unanimous jury conviction. That's why I was there. In the days and weeks prior, I had been brushing up on the subject in aid of serving as an expert witness in Maxey's appeal, rereading old files and discovering some of the amazing new work on non-unanimous jury trials produced since the original publication of Jim Crow's Last Stand. I was in regular contact with Richard Bork, director of the Louisiana Capital Assistance Center, a nonprofit that provided legal defense services to indigent defendants charged with capital crimes. This case, however, was different. Melvin Maxey wasn't on death row, but Bork had taken over the appeal, and in the process decided, like so many before him, to take on Maxey's non-unanimous jury conviction as part of his argument for a new trial. The plan was to deal specifically with the opinion in State v. Hankton, an opinion from 2013, in which Judge Dennis Waldron argued that, quote, the revision of a less than unanimous jury requirement in the 1974 Constitution was not by routine incorporation of the previous Constitution's provisions. To the contrary, the new article was the subject of a fair amount of debate. In that debate, no mention was made of race. The stated purpose behind the latest iteration of the less than unanimous jury verdict provision is judicial efficiency, he wrote. On top of that, the 1974 Constitution, he claimed, was submitted for popular vote. It was an interesting argument, but not one particularly difficult to disprove. Waldron reasoned that Louisiana's change from 9-3 majority verdicts to 10-2 majority verdicts in 1974 abrogated the original racist intent of the 1898 Constitution that created the non-unanimous standard. Because, he argued, the 1973 convention that created the new formula was not overtly proclaiming white supremacy, as had the Convention of 1898. The problem with such a claim was that it ignored history and context. It ignored the racial realities of early 1970s Louisiana. It ignored that the starting point for all discussions of the non-unanimous jury provision in 1973 began with the original standard as it had been formed in 1898 and reformed in 1913 and in 1921. And it wrongly assumed that the promotion of a provision with original racist intent and clear racialized outcomes by someone along the way who didn't happen to be particularly racist could make that provision somehow equitable. Well, in the course of reviewing materials to help make the case against such reasoning, I discovered a wealth of new information that had been published by legal scholars since the first appearance of Jim Crow's Last Stand. It was information that sometimes validated the claims of the book. At other times, it demonstrated that more needed to be said, that there were holes in my original account. The first edition of this book, for example, virtually ignored the role of Gilded Age black jury service as a motivating factor in the creation of the non-unanimous jury constitutional provision in 1898, and the implications of that role on the 19th century debate. It also ignored some of that racial context of the 1970s that would help respond to Waldron's Hankton opinion. It also couldn't help but leave out the legal developments since its original publication. In March of 2018, State Senator J.P. Morrell introduced a bill to amend the Louisiana Constitution to require unanimous juries for all criminal verdicts. It was successful in early June, and the amendment went on the ballot in November. Grassroots organizers canvassed the state. Former Grant Parish District Attorney Ed Tarpley campaigned tirelessly for the amendment. The Unanimous Jury Coalition formed chapters in New Orleans, Lafayette, Baton Rouge, and Shreveport. The issue gained bipartisan support across the state and ultimately, seemingly miraculously, passed by a wide margin. Well, the night before my testimony at the Sabine Parish Courthouse, I met with Bork, legal scholar Thomas Ward Frampton, who was also testifying, and a group of dedicated clerks in a first-floor motel room off the Natchitoches exit of Interstate 49. There were files stacked around the room, a printer in front of the television. I sat on the bed closest to the window, to the air conditioner, creating a cool breeze into a room that would otherwise be stifling with the heat of Louisiana summer and anticipation of the next day's events. We rehearsed the history of non-unanimous criminal jury verdicts, the line of questioning, the strategy of testimony. The others in the cramped motel room were used to such plottings, to the intensity of the night before a trial, but it was my first time. I told them all, giddy with anticipation, that it felt like a scene from A Few Good Men. Tom Cruise stalking around with a baseball bat as the defense team debated ideas and scribbled on a whiteboard in preparation for the day's events. Except that this wasn't fiction. Melvin Maxey was waiting in jail. A brief respite from the prison cell he normally called home, a grim reality only because his trial had happened in Louisiana. If it had taken place across the state line in Texas, a 10-2 verdict would have given him another opportunity, but this was Louisiana. I walked back out into the hot July night, back to my own motel room, to do more reading before the next day's events. My wife and I got to the courtroom early, anticipating a longer drive to Manny from the Natchitoches Freeway. Walking into a courthouse without a metal detector made her nervous, but I liked it. Where one might normally see signposts of diligence at other courthouses, here there were a few scattered magazines and a plastic bag filled with soda can pull tabs. We sat patiently in the hallway where the bailiff reassured us that the courtroom would open shortly. He smiled and assured us that we were in the right place. We entered when the courtroom finally opened. There was a sign on the door warning everyone who entered that no food, drink, chewing gum, or cell phones were allowed inside. But everyone was eating, drinking, chewing gum, and staring into cell phones. It was the relaxed atmosphere infused with the tension of a life hanging in the balance that one might expect in a courthouse without the metal detector. We sat and stared at the wood-paneled walls as Melvin Maxey's family made its way into the room, sitting in the rows in front of us. Then Maxey himself came in, chained at the wrists and ankles, wearing an orange jumpsuit, but smiling at those who came to see him that day. It was an all-day affair. First was testimony by conference call by a reporter from the New Orleans Advocate, who had been part of a massive research project by the paper to analyze the effect of the non-unanimous jury standard in the state, producing a wealth of damning evidence that non-unanimity created significant racial disparities in convictions and in jury deliberations. Then it was my turn, then Frampton's. We answered Bork's questions, then those of the prosecution. Looming over everyone was the realization that in November, there would be a statewide vote to end the practice that we were all debating. But there was something else looming as well. Someone in front of us had on a Sabine Parish Youth Baseball League t-shirt. We could only see the back of it, with all the names of the players dutifully listed in white on a red background. And among the Thompsons and Smiths, it was hard not to notice the name Maxie. This was a family that was embedded in the community. A large clan in a small town with at least a dozen members willing to take time off of work to come to the courthouse for a glimpse of their brother, cousin, uncle, loved one. "Oh my God," my wife whispered. "Take a closer look at the bailiff when he walks past again." He had the same open, friendly smile with which he had greeted us in the early morning, his brown uniform neat and imposing, as are all the outfits of law enforcement, his gun threatening, but not a threat. And then I saw it, his name tag, Maxie. It was, to both of us, somehow even more troubling than everything else we had seen that day. A grand demonstration of the devastating horror that non-unanimous juries could cause. I walked out of the courtroom that day, drove away from Manny and from Sabine Parish, knowing that I needed to produce this second edition of Jim Crow's Last Stand. In the fall, I gave a series of speeches at universities in the state in aid of drawing awareness to the issue before the upcoming November vote. Students at McNeese and Louisiana Lafayette and LSU and Louisiana Tech and ULM were engaged and interested in the subject. They were great. But what was most surprising was that though the bulk of them were from Louisiana, they didn't know that non-unanimous criminal juries existed. And why would they? If no one close to them interacted with the criminal justice system, they would have no reason to know. The state never advertised its system publicly and allowed generations of unsuspecting Louisianans to discover it only at their most vulnerable moment. Norris Henderson, a former inmate in the Louisiana penal system, wrongly convicted on a 10-2 verdict and later exonerated after serving decades in prison, explained on a Louisiana Lafayette panel that when he heard the jury's vote in his case as 10-2, relief washed over him. He thought he was free. Then the harsh reality of the next 2 decades came crashing down upon him. Future Norris Hendersons, however, will have a better chance at justice. More than 64% of voters approved Louisiana's new unanimous jury amendment. Jim Crow's Last Stand finally fell to defeat. And as the book explains, as it moves into its substantive arguments, non-unanimous juries in Louisiana were the product of an overtly racist postbellum system that attempted to re-enslave the black population by generating a glut of convicts for the convict lease system. It also attempted to mitigate the power of black jury service by eliminating the potential power of a minority of black jurors that might serve for a given trial. It was an act of 19th century racism with 20th and 21st century racial consequences. since Jim Crow's Last Stand, since the second edition here of Jim Crow's Last Stand has appeared, even more has happened. In April, the United States Supreme Court ruled in Ramos v. Louisiana that non-unanimous criminal juries were a violation of the Sixth Amendment right to a jury trial. It was a signal victory, but it is one that has still yet to pay off for others languishing in prison and who want the decision to apply retroactively to them as well. Just a week ago, on June the 3rd, the Louisiana State Supreme Court narrowly decided in Louisiana v. Willie Gibson to refuse to hear an argument about the retroactivity of Ramos after the U.S. Supreme Court decision. But there is still hope. Chief Justice Burnett Johnson wrote a blistering dissent and a strong statement on the role of race in such decisions. The fight, then, continues. And that fight is particularly relevant in the present moment of what I would call here this urban spring, this moment of protest in which we find ourselves in response to the police killing of George Floyd. Because Jim Crow's Last Stand is about non-unanimous criminal juries, but that makes it fundamentally a story about criminal justice. And Louisiana's long effort to reckon with its failed system of criminal justice mimics our current moment. In new efforts, for example, to defund the police and to remedy police brutality more broadly, we often pull cops from the narrative, singling out policing as the big bad enemy without contextualizing it as part of the broader criminal justice system, which doesn't have batons and guns and chokeholds, but is just as powerful in its structural racism. For Louisiana, non-unanimous juries are, or were, a constant and constituent part of that system. Black defendants in Louisiana went to prison and go to prison easily because the system was set up to make it easy to put them there. But the cops featured in all the videos on television right now, for the most part, don't go to prison. That isn't a problem with just policing. That is a problem with criminal justice writ large. And until we make Ramos retroactive, until we as a state are willing to provide new trials to those languishing in state prisons after two jurors in their trials said that they were not guilty, we will continue to carry a scarlet letter that does just as much damage to Black lives than any racist, violent cop. We have made good progress, but there is more work to be done. And this moment of people's uprising, and in this moment, Louisiana needs to take advantage of it to make changes in its system. For every cop not in jail after abusing his authority, there are hundreds in Louisiana prisons in jail after jurors said that he was not guilty. A reckoning in criminal justice demands that we address both of those concerns. And I will stop there and see if any of you have any questions. I am happy to answer any questions you might have. If you do, I will happily talk about anything you're interested in. If not, I will give you a few statistics about the real problematic nature of how the Louisiana system has developed. So before I do that, does anybody have any questions that I can answer for you? No, you're all very shy. That's okay. I get it. let me describe a little bit more then. Let me take a few more minutes to describe some of the consequences of these actions. This is also material from the new edition of Jim Crow's Last Stand. In 2005, Louisiana incarcerated 523 white people and 2,452 black people per 100,000, a differential of roughly 4.7 to 1. And that sounds staggering. It sounds insane that that could even be a statistic. But in fact, that differential was actually below the national average. The national average was actually 5.6 to 1 in 2005. Keep in mind that the black population in this country is around 12 or 13%. 5.6 to 1. And the reason for that is because while Louisiana's rate of incarceration for black prisoners was higher than that as a nation as a whole, so too was its rate of incarceration for white prisoners. That's what happens when you put people in jail when only 10 of the jurors think that they are guilty. The differential between black and white prisoners was highest that year in Washington, D.C., whose ratio was a mind-bending 19 to 1. It was lowest in Hawaii at just around 2 to 1. But when the best a state can do, is to incarcerate twice as many black prisoners as white per 100,000, the system is obviously weighted racially. And when a state like Louisiana creates a mechanism whereby convictions become easier, it only feeds that racial system and only makes it more problematic. As of 2014, a few years ago, Louisiana had more than 38,000 people in prison, a rate of about 816 per 100,000 citizens. It was not only the highest rate of incarceration of any state in the United States, it was one of the highest rates of incarceration in the world. As a point of reference, Russia only incarcerates 492 people per 100,000. China, 119. Iran at roughly 450. We best them all. And those numbers don't count the more than 69,000 people still part of the criminal justice system because of parole. For those still in prison, the largest facility is still Angola, the original home of the convict lease that started this whole system in the first place and encouraged non-unanimous criminal jury verdicts to put black citizens into convict lease system. Angola has more than 5,000 prisoners. The average sentence for people who serve there is 93 years. 95% of Angola's prison population will die there. More than 400 of those serving life sentences are serving them for non-violent crimes. And more than half of those were convicted by non-unanimous juries. When two people on that jury said that the non-violent crime that they are now serving a life sentence for, they were not guilty. The New Orleans Advocate, who I mentioned earlier, produced a massive in-depth study of the modern outgrowth of this practice on black defendants, for which they won a Pulitzer Prize last year. So well deserved and so important, their work. The paper was able to collect data from roughly 3,000 cases in the state from 2011 to 2016. 993 of which included the documentation of individual jury votes. The paper found that 40% of convictions came at the hands of a non-unanimous jury. 40%. When the defendant was black, the statistic rose to 43%. When white, it decreased to 33%. The study also examined the jury pools of the state's 9 busiest courthouses and found that those pools were substantially whiter than the surrounding population. The actual juries pulled from those pools were whiter still. Only one such jurisdiction adequately reflected the black population on its criminal juries. The rest disproportionately reducing their presence by anywhere from 10 to 42%. It was a misrepresentation made all the more significant because, as the study showed in a review of 46 non-unanimous criminal convictions in East Baton Rouge Parish, black jurors were 2.7 times more likely than their white counterparts to vote against the majority. And in a state with the highest incarceration rate in the world, with a black population that is roughly 1/3 of the total, but 2/3 of the prison population, and 3/4 of those serving life without parole, with far more serving that sentence than in any other state, the role that the history of Louisiana's last Jim Crow law played in that development seems even clearer. And the role that holistic criminal justice plays in these systems of oppression that is so much on the minds of everyone today in this urban spring is too important to let go. Police disproportionately harm black citizens. They kill them for having toy guns, for maybe possibly passing a $20 bill, but maybe not, for driving while black, for questioning a traffic stop. But those ugly incidents, the crimes that take place on cell phone cameras and on the news that follow, are aided and abetted by a broader system that has at its heart the jailing of as many people as possible. It used to be because Louisiana wanted to live up to its promises of convict lease. Now it is to live up to the promises of private prisons. But the only way it can do that isn't just with the tip of the spear, the policemen that we see on those video cameras. It's also with the broader system of criminal justice. And in Louisiana, that system has been aided and abetted by non-unanimous juries since the 1880s. And until we get retroactivity for Ramos, until those hundreds of people languishing in Angola for non-violent life sentences where 2 jurors said they weren't even guilty, until they get a new trial, our criminal justice system is going to remain part of the problem. Hopefully, the new edition of Jim Crow's Last Stand can help start a conversation to help us figure out how to get rid of those structural inequalities. And so again, this is the book that I'm reading from here, Jim Crow's Last Stand. It is available at LSU Press, who is doing a sale in conjunction with these talks. You can not only get a copy of that, but you can also get a copy of all the other amazing authors' books that have been doing this reading series. I would also encourage you, if you are interested in this subject, to not limit yourself to this book. But as you are watching on television all of this new thinking about structural criminal justice reform, that you also take a look at studies like that of the New Orleans Advocate. They have a variety of articles cataloged on their website in a specific section dedicated to this. They also have easy infographics to read for those of you who are click-averse or internet article averse that can make a lot of these points very clearly. And it's important for us to understand as Louisianans, and if we have anybody here from Oregon, I think it's probably important for you too to understand that we have an extra mile to go than everybody else when it comes to remedying the problems of racism in criminal justice, and we need to tackle that head on, and the original part of that tackling is going to be retroactivity. Does anyone have any questions? Anyone? I'm happy to answer them. Okay, well, if there are no questions, I really thank you for watching. I encourage you all to check out what you can do in your communities to help fix some of these structural problems in criminal justice, whether it be problems specifically related to Louisiana's system or to the structural racism that we see in everyday life today. Hopefully this will help encourage you to get involved, because it is going to take all of us to make the kind of changes we want. But thank you for watching, and I hope you all have a great day. Thank you. Hey everybody, I'm back. I was told that there are questions. I just can't see them. So even if you guys are gone, I will try to find them now and answer them, and hopefully you can rewatch this and see the answers to your questions. I really apologize for that. I actually still can't see them. Pickle, can you see them?
No, but I see people that commented that you can't see them.
Can you see the comments? Mm-hmm. What are they saying? Are there questions? For some reason, it is not showing me any of your questions. So, did you see any questions, Pickle?
I think your friend Shannon said that she could see questions.
Josh said he could see questions. Josh, if you are on here, if you could cut and paste me the questions, because hi, see, I can see some people commenting now, but I couldn't see it during the talk itself. For those of you who are just coming on and who were not on before, I have already done a reading from Jim Crow's Last Stand and talked a little bit about criminal justice reform. I am going back now to try to answer some people's questions because it is not showing up for me. Okay, let's see. I have some of the questions here. Okay. Neil asks, where does the issue stand in Oregon, the last state to accept non-unanimous jury verdicts? That's a great question. Oregon is dealing with this right now. They had tried, after the new edition of the book came out, I had talked to several groups in Oregon, and the Oregon legislature, the Democrats in the Oregon legislature were planning on putting forward a bill to change the process. They weren't going to do theirs by constitutional amendment. They were going to do theirs just by law. But there was a situation after Louisiana's vote in which the Republican legislature in Oregon, not because of this issue, but for other kinds of political infighting issues, walked out of the legislature and essentially went on strike, leaving the Oregon legislature without a quorum for several months, and therefore nothing could get done. Now, however, after the Ramos decision, Oregon is forced to kind of recognize that the process is no longer constitutional. So now Oregon's system is going away as well. The problem is that as they are kind of having to end their process because of the Supreme Court, they haven't even gotten to debates about retroactivity yet. So the people who are in jail because of a non-unanimous jury verdict in Oregon have yet to have their day in court to see if those appeals would be effective. Hopefully, the protests that are going on now are going to force the hands there a little bit. We hope to get retroactivity, but Oregon is now, after the Ramos decision, giving up non-unanimous criminal jury verdicts too, even though it didn't happen with the same alacrity that we were hoping it would happen. We had to wait for the Supreme Court. Okay, Laura asks, how does it feel to have been so integral to the law in Louisiana and on the federal level being changed? It's been crazy. It's really weird. As historians, we tend to assume that we are writing about things that have already happened, and while we enjoy the fact that we have an audience that likes to read history, we don't normally expect our work to make changes in the present. And also, I should say that we don't typically claim to speak for the present. Certainly, I am not a sociologist or a lawyer by trade, and so I feel far more comfortable discussing past things than present things. But I have to say that when you see your name cited in a Supreme Court decision, I mean, it's pretty cool. I have to admit, it's pretty cool. But I'm just happy that I could help. I am not the one who did most of the work here. I just wrote a book. There are so many people on the ground: Norris Henderson, his vote group, the Unanimous Jury Coalition, Ed Tarpley. Those people in Louisiana who actually still live in the state are the ones who went out on the ground, knocked on doors, leafleted, put up signs in people's yards, got people to vote, assembled a massive coalition that really bridged partisan divides in an era that is so divided partisanly. I mean, Oregon, for example, had to stop their legislature because Republicans walked out. Meanwhile, in Louisiana, Democrats and Republicans got together to do this. And while it was instigated by a movement on the left, it was voted on by a plurality of Republicans as well, who saw the benefit in doing this. And so in a time of partisan rhetoric, the idea that we could get this done really speaks less to the historical work that I happen to have done, and to the work on the ground of the advocates of this position that really did all the hard labor. I would also be remiss if I didn't mention that there are a variety of other scholars who are working on this subject, who were doing important work. Just to name a couple of them, I should say that Angela Allen Bell from Southern, Kyle Satterfield, all of the reporters from the New Orleans Advocate, and Thomas Ward Frampton, who is, I think, still at Harvard. He's about to be at the University of Virginia, who testified with me in that case in Manny that I described in the reading, and who has done amazing work on this subject as well. So it is great to be a part of something like this, but having your name on the book, I think, gives you more of an outsized claim to influence than you really have. The real people who did this are still in Louisiana, and I'm just happy that they exist. They all deserve so much of the credit. Okay, this is from Josh Butler. Hi, Josh. Josh is a former student of mine. Do you have any backlash from trying to explain non-unanimous juries in the same fashion that you might face in explaining police brutality or the troubled history of monuments? The short answer to that question is yes. There has been pushback against this. As a matter of fact, the sheriff of that very parish, Sabine Parish, where Manny is the hub, was one of the leading defenders of non-unanimous criminal jury verdicts, arguing that this is the way we've always done it. It's the way we should do it. The Secretary of State, I don't think he is still the Secretary of State. Maybe he is, but the Secretary of State in 2018 came out very much opposed to it, worried as he was about his conviction numbers and how they might be affected by this change. And so there has been pushback, but not to the same degree as if you want to talk about the prison abolition movement or the defund the police movement or anything like that. It certainly doesn't have that rhetoric. My friend Karen Cox, who writes about Confederate monuments, gets all kinds of crazy emails from people who are opposed to taking down Confederate monuments. I don't get those emails. The only times I've really been challenged on this are at talks, when people come to the talks to kind of confront the person who wrote that book. And that's not really that big of a deal. They're easily dealt with. But for the most part, people get on board. As I mentioned, this has been very much a bipartisan issue. A lot of Republicans in Louisiana got on Focus on the Family. I mean, was sponsoring advertising for getting rid of non-unanimous criminal juries in Louisiana. So, I mean, some of the most radical right-wing groups supported this, and in a way that I don't think they would for Confederate monuments or prison abolition or police brutality stuff or anything like that. Let's see. Okay, I think those are all of the questions. I apologize for not seeing them earlier, but hopefully these answer your questions. If you weren't able to join us for this, hopefully you'll see it on the LSU Press Facebook page. And if you have any more questions, please feel free to contact me. You can find me on Facebook at Thomas Aiello Books on Facebook, facebook.com/Thomas Aiello Books. You can find me at thomasaiellobooks.com, or you can find me at my department page at the History Department and the African American Studies program at Valdosta State University in Georgia. Sorry about the question thing. Thank you for having me. It was nice to see you, Louisiana. I miss you, and I will talk to all of you. Soon. Thanks so much.